So a loved one has passed away, you're a beneficiary, and you come to find that large gifts have been made before they died. You suspect they might not have understood the consequences of these gifts, or perhaps they were forced into it. So what should you do? Lack of understanding comes down to mental capacity. If the deceased didn't have the required mental capacity, then the gift will be deemed invalid. There is a specific test for this, and it comes down to whether the deceased would have understood the consequences of the gift had it been explained to them at the time. Could they understand the information relevant to the decision, weigh up that information, retain the information, and then communicate their decision? The level of understanding required depends on the size and nature of the gift. So the larger and more complex the gift may be, the greater the level of understanding required. Not only is understanding key, but intention is too, and this is where undue influence comes in. There are two types of undue influence: actual undue influence and presumed undue influence. Actual undue influence is where the deceased's free will has been overridden by another. It is for the person making this allegation to prove there was coercion. Presumed undue influence applies where there is a relationship of trust and confidence and a gift which calls for explanation. If this presumption applies, it's not for you to prove it, it's for the person who received the gift to prove that it didn't happen. The types of relationships could be that of doctor, patient, solicitor, client, and attorney and donor. But it could include families too, such as parent and child, and even child and parent if that parent is vulnerable. Whether a gift calls for explanation depends on its size and nature. A simple £250 gift might not call for as much explanation as a gift of property. It doesn't have to be one big gift though, it could be a series of little gifts. Not only can gifts be an issue for your estate, but it can also be an issue for you during your lifetime. If you have appointed attorneys or deputies to manage your finances on your behalf, they are subject to very strict rules on gifting. They can make gifts to charity or to family and friends on customary occasions, such as birthdays, Christmases and weddings. But to go above and beyond this, they do need the approval of the Court of Protection or from you if you have mental capacity to give that. If you have a question over gifts, whether you're a disappointed beneficiary or someone who received a gift that's being questioned, or even an attorney or deputy that wants to make a gift, we can help you. Just call our client coordinator who'll be able to put you in touch with a member of the team.